Swayam Prabha. Digital India. Educated India.
Opposition proceedings to grant of patents. Section 25 deals with opposition to the patent. Section 25(1) deals with opposition before the grant, which means a case where you can oppose an application, a patent application. It is also commonly called pre-grant opposition. And section 25(2) deals with post-grant opposition or opposition after the grant of a patent. So, the main difference between these two types of opposition is one happens before the grant and the other happens after the grant. Pre-grant opposition, the rules are much relaxed, as you would see. The status of an opponent is also much wider, and it's a summary proceeding. And now we have decisions of the High Court where they have held the role of a pre-grant opponent or the person who opposes before the grant is that of a person who aids the examination. So, he is actually like a person who helps the examination of the patent. So, in law we have amicus curiae, something similar to that, a friend of a court. So, he can be regarded as a friend of the patent office because he helps or aids in the examination. Post grant is different because in a post grant opposition, the post grant opponent gets a party status. There are forms, there are fees to be filed. So, he is regarded as a party, and post grant opposition is regarded as an inter partes proceeding. The TRIPS agreement under the WTO has different kinds of proceedings, and one of the proceedings is inter partes, between parties. A contentious proceeding is called as an inter partes proceeding. The post grant opposition qualifies for that. Pre-grant may not qualify for an inter partes proceedings because a pre-grant opponent does not have a status of a party. He does not file fees, for instance, or he does not have a remedy in appeal. So, if the pre-grant opponent loses the opposition, there is no remedy in appeal. He cannot file an appeal to the IPAB. That is not open for the pre-grant opponent. The law is quite settled now because of a few decisions of the high courts. So, be it pre-grant opposition or post-grant opposition, they can be initiated on common grounds. The grounds are common. All the grounds for pre-grant opposition and post-grant opposition are common. The only difference being the point at which you raise those grounds. So, when in pre-grant you will raise all those grounds when the application is still an application and it has not materialized into a grant. In a post-grant opposition, you would raise the same grounds, but after the grant. And the procedure is also different for pre-grant and post-grant. There is an opposition board that is constituted for the post-grant, which is now there for the pre-grant. So, as we go, we will be able to see these two procedures in greater detail, and we will also tell you how the law has evolved, and we will also share some details about how the current practices happen.